Antitrust case against AI overviews. I'm Teddy Downey, executive editor here at the Capital Forum, and today's guest is Madhavi Singh, deputy director of the Thurman Arnold Project and resident fellow at the Information Society Project at Yale Law School. Her research focuses on antitrust regulation of digital markets, the economic and non-economic effects of monopoly power, and consolidation in the AI supply chain. Before joining Yale, she worked as an antitrust associate at Shardul, Amarchand, Mangaldas and Company in India, and as a lecturer and researcher in Singapore and India. Holds a lot of degrees from the National Law School of India, University of Oxford, Harvard Law. Wow, very impressive stuff. We're excited to be talking to her about her recent paper, The Antitrust Case Against AI Overviews, exploring how generative AI tools like Google's AI overviews may be reshaping competition in the digital ecosystem. Madhavi, thank you so much for doing this today.
Thank you for having me.
And if you have questions, as usual, throw them in the questions pane over here in the control panel, or you can email us at editorial@thecapitalforum.com. Madhavi, would love to just start off, how do you think of this paper? How did you come up with the concept? And then maybe we could get into, sort of the highlights from there.
Yeah, glad to do that. So this idea in many ways is not really new, because I think people who've been working in the space of platform regulation have been privy to the conversation about how Google has been eating the lunch of publishers. Publishers have been complaining about this for a very long time, that they are heavily dependent on Google for referral traffic, and they have very little visibility or control over how their content is curated, ranked, presented, but also how much traffic they receive and how much of the from what percentage of the ad revenue from Google they receive. So in many ways, this isn't really new. Even the use of publisher data or public excerpts from publisher content by Google, that had been happening for a while now. So Google had all these features like knowledge panels, which appear on the right-hand side of the Google search results page. And there are featured snippets and Q&A where it had already started using publisher excerpts without their consent or without additional compensation. When AI overviews and AI mode was announced, it seemed like it was sort of the final nail in the coffin, so to speak, because, and even when it was introduced, a lot of publishers predicted and could foresee that this would further decrease click-through rates and result in an increase in zero-click searches, result in an decrease in traffic, and an associated decrease in ad and subscription revenue. A few months after these features were introduced, a lot of reports and studies started coming in that publisher traffic had reduced by 30%, sometimes more, and there had been drastic decreases in ad revenue as well, which was obviously negatively affected a lot of publishers. So that was the motivation behind the paper. I realized that this is not really something new, but it was a moment when we needed to act. There was a greater urgency to it because it had become really existential for publishers.
And I think, I know you say it's not new. I mean, I think some of the harms are certainly not new, but you've applied, this Section 2 framework in a very detailed way, specifically to Google AI, and maybe you can walk us through just on a high level why this is a compelling case, and then we can kind of get into the mechanics from there. But we've got, I'm sure, people from DOJ and FTC listening in here. Why is this, a priority, or why is this a particularly good application of monopolization law?
Yeah, so you're right. I think the harms were evident, but what what was needed, or I felt was needed, was explaining how this can be captured by existing theories of harm. So Section 2, illegal monopolization. So to unpack that, I think it's useful to think about what is the relationship between publishers and Google. So the original bargain on which the internet was based was that publishers allowed Google to crawl their websites and to create its search index, and in return, Google sent traffic to publishers, which then publishers used to monetize their content. So that was the original bargain of the internet. So it was referral traffic in return for publisher data. But as Google's power in referral traffic started increasing, it started extracting more for less, which is classic abuse of monopoly power. So how did it extract more? What changed? I think how it started extracting more from publishers was that it started using this publisher data in all these additional ways for AI training, AI grounding, for summarizing publisher content in AI overviews, in Gemini and its other chatbots, and also for republishing publisher content directly in AI overviews and some of its other search features. So there was all this extra extraction that was happening because Google had this monopoly position in referral traffic and in search, and it was paying less. As it was paying less for extracting, while it was extracting more, it was paying less because now publishers were getting less traffic and less ad revenue. And to me, that seemed like a classic abuse of monopoly power. Well, to be exact, it's actually monopsony, not monopoly, because while monopoly is a market in which there's a dominant seller, monopsony is a market where there is a dominant buyer. So in this case, Google is acting as a monopsony. It is the dominant buyer of publisher data, which allows it to buy this publisher data at lower than competitive prices. So it allows Google to buy publisher data while sending less traffic and less ad revenue to publishers. And abuse of monopsony power, like abuse of monopoly power, is a violation of Section 2 of the Sherman Act. So that briefly is the theory of harm that I think sort of captures what Google is doing to publishers here.
And I want to get into, the exclusionary conduct in a second, but before we get there, I want to take a quick step back, because when, something that occurred to me when I was reading your paper and when you were just speaking there, when Google search started, the courts were much more favorable to big tech. Google got a lot of really good copyright rulings on scraping, on Google library, I forget that exact case, but when they were putting the books, Google Books.
Yeah.
And to me, and you get into this a little bit, but the courts have seemingly, even though they're mixed on AI and copyright violation, I think the way that Google is acquiring the information is much more legally dicey. Or is it fair to characterize it that way? Because obviously they got all those favorable rulings on search when it came to setting up the crawler and scraping, but this is really a different mechanic in some respects. And I'm wondering if that foundation and where the courts are make this a little bit actually easier of a time to make this type of case, or is that not relevant? Because you do mention that some of the courts actually have been allowing fair use, but I would say it's decidedly more mixed or problematic. We did a recent copyright conference call on AI that has me a little bit more pessimistic about Google's chances of AI getting away with training and publishing when it comes to copyright. But just want to, before we get into some more mechanics, just want to get your reaction to that.
So I have mixed feelings about it too. I think that some of the copyright rulings, which viewed as fair use, make me a little bit less optimistic. At the same time, I feel that this is a distinctive this is a distinct violation because it's antitrust. It's about having monopoly power and exploiting that monopoly power. And perhaps in some ways there will be spillover of how those IP cases have been determined. But I think that one could also imagine that courts have had a few favorable rulings when it came to abuse of monopoly power or recent Section 2 monopolization cases. So it's difficult really to say which way it'll swing. But what makes me optimistic is the idea that there is an acknowledgement that big tech power is problematic, and therefore we cannot allow Google to illegally monopolize all of these markets. I think another good thing is that courts really struggle to find remedies in the Google search case. And it was also because it's difficult to find remedies and restore competition in digital markets once it is lost. And I think experiencing that probably should make courts and regulators act faster, because they know that competition once lost in these new markets is very difficult to restore, and hopefully that will nudge them to act on these. But my guess is as good as yours on this.
Yeah, no, I mean, I think that point comes through in the piece also, that, you know, if we've learned anything, getting ahead of this monopoly, exercise of monopoly power is better than trying to solve it after the fact. And maybe we could get into a little bit of the mechanics here of what a case would look like. You know, obviously, if the DOJ and FTC is interested, they're going to do a whole investigation into this. But you start off, you talk about exclusionary conduct here, and it's really how Google affects publishers. Can you walk us through that, that exclusionary conduct and what that, we've mentioned it already, but what ends up happening to the publishers based on that exclusionary conduct?
Yes, so the exclusionary conduct is use of publisher data without their consent and without compensation in all these additional ways, and also republishing their content without consent or compensation. That's the exclusionary data, the exclusionary conduct. And how it affects publishers is that there have been reports of decrease in click-through rates, increase in zero-click searches on Google, and an associated decline in revenue and associated decline in both traffic and revenue. And I think this has consequences for like the broader media ecosystem. We're already in a media ecosystem where there are trends of consolidation. Local news is struggling to survive. Against this backdrop, the fact that the ad revenue of publishers is drying up even further should be even more concerning. And I think like just to sort of drill in on the harms even more, I think it's obvious how publishers are being harmed and how that might affect media, information generation, and even democracy, for example. But I think users will also be impacted. And I think this is a point that is much less discussed, because right now we have the option to choose between so many different publishers. There's New York Times, there's Wall Street Journal, and fewer local news publishers, but some of them still exist. But as the costs of operating for these publishers increases and ad revenue dries up, a lot of these publishers will exit the market. So users will have less choice of content, and publishers will be able to invest less in journalists and in editors, which would also affect the quality of services that user gets. So the quality of original content will be affected. And one could even go further. This will have effects on even AI chatbots. So right now, AI chatbots have so much training data because publishers are producing original content, which they can train on. But as publishers exit the market, the original content available for training AI models will decrease, which will also affect the quality of AI models. So their quality will either plateau or it could even deteriorate. So it could have like spillovers on so many different markets. But I think that there is a very clear case to be made of harm on both publishers and consumers.
I've also, not just the models themselves, but often the models, when you put in the chatbot, the model will then go do its own Google search to get more information. And then, they're going to be searching your sites, that you have fewer sites, and you're going to get a worse outcome from that. So you also mentioned not only that Google is scraping websites without consent or compensation to train the models. You mentioned publishers have no recourse to resist this.
Yeah.
and Google's critical for these companies to get discovered and to distribute. Can you talk a little bit more about that? I think this is kind of glossed over sometimes, that, you know, these are critical distribution channels, and there's no, there's no real recourse for the publishers. Maybe we could talk about that for a second.
Yeah, no, that's a super helpful question. And I think it's very interesting because this came out during the Google trial. There was this internal document that was released during the internal Google document that was released during the Google trial, where Google was discussing whether and how it should use publisher data for AI training and what were the different options that it could give to publishers. So should it give publishers the option to opt out of their data being used for AI training while still allowing them to be indexed on search? And they decided against it. And there was a period when Google gave publishers the option that their data is used only for search index, but not for AI training, but they never ended up honoring that code. And all of this came out during the Google search trial. So currently, as it stands, publishers don't really have a recourse to opt out of their data being used for AI training. If as a publisher, you want to be on the search index, and of course you want to be on the search index to be discovered, then you would also have to agree to your data being used by Google for all these AI training purposes. So that's a sort of a tie-in, and users don't really have an opt-out option. And even when there was an opt-out option, Google did not sort of honor it. There have been some companies that are trying to find workarounds, but it's really difficult. So for example, Cloudflare early this year, which Cloudflare is this company which routes most of the internet traffic. I believe it's around 16, probably more than that, a large percentage of the internet traffic. It announced that it would block AI crawlers by default. And publishers could then, at least for the publishers that it handled, and publishers could then choose if they want to allow AI crawlers. But that, once again, there we are relying on this private company, which has a lot of power to do this for us, when instead we should have like better ways to take care of this. But currently, publishers at least have no way to opt out of their content being used by Google for training its AI models if they want to be on the search index. So it's either like all in or all out.
I want to get more into tying in a second. There is another aspect of this exclusionary conduct that I want to talk about, which is not attributing properly, or misattributing, as you describe it. And maybe we can talk about that. Is there a lot of evidence that happens, and how is that problematic from a legal standpoint?
Yeah, so there is evidence. A lot of these studies are still being conducted, but we already have early evidence of how Google has started attributing less content. So it started out with more links. Now it has less links on its AI chatbot answers. Additionally, it sometimes uses content without actually attributing sources at all. And once again, like, publishers have been at the forefront of showing that this happens anecdotally. And there are also some studies which show that this actually in fact happened, but like most of these studies are like qualitative. It's difficult to sort of see how many times Google has actually done this. But we do see that there is evidence of Google using content without attributing it, especially in the context that you mentioned, when apart from just like usual AI training, when chatbots go out and look for content once again, when you look for something more contemporary, like a news item, and they go out on the internet and start looking for that content, especially in those cases, there is a lot of like absence of attribution. So there's certainly like that's definitely happening. In terms of how that's a problem legally, I think it's once again like abuse of monopoly power just does not just take or abuse of biomonopoly power does not just take the form of extracting monopoly rents or higher prices or lower than competitive prices. In this case, it's not just price oriented, but also quality oriented. It's about if you as a monopoly can impose more exploitative terms, that is also an abuse of monopoly power. And in this case, I think imposing these terms, not attributing when you're taking content from publishers, that is an exploitative term, which is an abuse of monopoly power.
And then you also mentioned Google prominently placing AI-generated answers at the top of search results, making that more and more and more of what the user sees. How is that problematic?
Yeah, so there's this very interesting study which showed how Google had been increasing the percentage of the screen that was the percentage of the screen on which AI overviews appears, and it has been gradually increasing the percentage of screen that's assigned for AI overviews as opposed to organic search results. And this is especially problematic when you're viewing things on the mobile phone and you have a smaller screen, because most of that space is taken up by AI overviews. And this is, again, we know from Google search and a lot of studies that have been done, if something is at the top of the search results page, it's more likely to get clicks. And it's the same with AI overviews. The fact that it is at the top and it's also prominently displayed in this sort of separate box, it means that most users now read what's in the AI overviews. And if it's just a small query, a lot of them don't click on even links that are present in the AI overviews, forget scrolling down to the remaining search results page and clicking on some of the publisher content down there. So yes, definitely, like having AI overviews at the top and also prominently displayed further exacerbates the problem.
And we've already mentioned this, but now that we've kind of gone through all the exclusionary conduct, and we've talked about some of the impact on publishers. Obviously, traffic is massively down. You hear about publisher layoffs all the time. You already mentioned the decline of newspapers and threat to democracy and all of that. Are there any other anti-competitive effects that we should think about that this case would bring up, this hypothetical case could look at?
Yeah, so I would like to point to two additional things. I think that this type of conduct also helps Google maintain its monopoly in the general search services. And we know that Google already has a very strong monopoly. It has had market shares of between 88 to 90% over the last several years now. So this type of conduct allows Google to maintain its monopoly position in general search services. How does it do that? Because Google, as a monopoly buyer of publisher data, like we discussed, it's able to get this input for lower than competitive prices. But none of the other search engines like Bing or Yahoo or DuckDuckGo or even new entrants, because they don't have the same market power as Google, they would not be able to get this publisher data at this lower than competitive prices that Google is getting it for. And so it makes it difficult for its rivals or even new entrants to compete with Google on a level playing field in the market for general search services. So this conduct has implications for Google's monopoly maintenance in general search services too. So I think that's one bucket. Apart from that, I think it's also useful to think about this problem just like more broadly, and to think about Google's position in a bigger ecosystem. So Google, of course, is at the center of this ecosystem. It controls so many different apps like Maps, YouTube, and it also has relationships with third parties like Apple and Samsung. And Google can leverage all of these, like this ecosystem which it has, and also its pre-existing relationships with third parties in ways that ensures that its attempted monopolization of AI chatbots, etc., actually becomes successful. And we see this happening. So in the aftermath of the Google Remedies decision, once Google knew that Chrome was not being divested, it immediately put Gemini on the Chrome browser. And it is now bundling Gemini with all of its apps. So you'll see Gemini very soon on Maps and YouTube and all of Google's other apps. So this type of conduct where you allow Google to use publisher data in all of these ways will have spillover effects, because Gemini will not just stay as AI overviews and search, but it will also be used across a suite of different apps, which would make it even more difficult to think of a remedy when you do try to unbundle it, right? And it will have spillover effects on so many more markets. It would entrench Google's position. And similarly with third parties, Google has started, and very similar to what it did with search, Google has started entering into deals with Apple and Samsung to put Gemini onto their smartphone devices. Another like classic thing from Google's playbook in the past that we see happening. So like Google's position in this ecosystem, it's just so strong that it will have effects like across a range of different markets, and a range of different sets of consumers will be affected.
Before we get to the pro-competitive justifications, the defense from Google that could crop up here, you know, one of the things we saw was that the people who were dominated by Google in the past, publishers, Yelp, they were very loud complainers. In this instance, when you're tying all of these products to the Google's just tying it across all of their entire ecosystem, who is going to be harmed in addition to the publishers? Like, what's the Yelp of this strategy? Is it OpenAI? Is it the other chatbots? Like, who are the people who are going to start complaining about this, conduct?
So I think it's unlikely that it would be the chatbots who would bring antitrust. The other AI companies would bring antitrust suits, because as monopolies of the future, you might not bring cases against monopolies of the present. History will not remember you very fondly for that. But I think that there are some Yelp equivalents. So for example, in the US, there are already 2 complaints that have been brought on similar theories of harm. And one is by Chegg, this online education company, which claims that Google ends up using most of its content to answer student questions and AI overviews, and then no one clicks on the Chegg website. And because of that, it has had a drastic decline in revenue. So you certainly have like these companies which are like Yelp equivalents. And of course, you have traditional publishers who don't have a lot of bargaining power vis-a-vis Google, but they're still big, well-resourced players. So for example, Penske Media, which is the owner of Rolling Stone and Hollywood Reporter and a few other publications, also brought a complaint against Google on a very similar theory of harm against AI overviews and AI mode. So we definitely have these like ready private litigants, but I think that you do, because of a case of this scale, and because I believe it implicates the future of the internet. It's again something that I've mentioned in the paper, and maybe we could discuss that briefly as well, that it implicates the future of the internet. I think it is insufficient that you just have private litigants bringing cases. I think given the scale of this, that the government, the federal regulators, or at least the state AGs should get involved. But I'll stop there. And we also mentioned like the success and how, like, what's the likelihood of success, etc. And I think that like maybe the rhetoric of national security that sort of colors every AI regulation discussion has got something to do, will also affect the likelihood of a case being brought or the likelihood of success. But I'll speak more about that in case there are more questions, or maybe we can touch upon that later.
Yeah, at the end, I want to talk about, why DOJ or FTC should at very least launch an investigation and take these arguments very seriously. But before we get that, I just want to, you make so many good points in the paper. I just want to kind of get to a few more of these. Google is obviously going to come up with their defense, their justifications for this. Again, I think a lot of this goes back to just the framing of the big tech of like, we should be allowed to do whatever we want, and that's kind of carried the day for them. Businesses, the government shouldn't be able to tell business what to do, that type of thing. But if you could, lay out what Google's justification for this is, I would, and then maybe we could get into tying after that.
Yeah, so I think Google's justification, at least right now, the justification there is little publicly available justification, but Google claims that AI overviews actually helps publishers. It allows a more diverse set of publishers to have access to the eyeballs in the beginning, because it's possible that some not so well-known publishers might be featured in AI overviews, etc. So it denies the idea that having AI overviews in search results actually results in decline in publisher traffic, whereas we have a lot of studies showing to the contrary. So that's Google's claim, that it just denies that publishers are negatively affected because of this. But I think when this becomes an antitrust lawsuit, we will also have Google making more technical claims, like trying to argue that this is actually just a product design. It's a design improvement rather than two distinct products that are being tied together. So there is no tying. If you just like improve your product in some ways, then that's not a distinct product that you're tying together with something else. But that's not an argument that Google has made just yet. But I think that like once an antitrust suit is brought, and it has been brought, Google will probably make those arguments then.
Yeah, we've seen Google argue, depending on the venue, oh, it's the same thing, oh, it's different from search or an AI, depending on where they are. So it seems like you agree that that is sort of an important thing to keep an eye on, how they position themselves around, is it distinct product, is it tying, that is worth keeping an eye on. Now, when it gets to tying, that's obviously another aspect of what a case would look like. How do you see the facts of what Google's doing here fitting into tying allegations?
So I think that the two ways to see this as a tying violation, or two different sets of conduct that can be seen as a tying violation. One is Google putting AI overviews at the top of the search results page, or Google tying AI overviews and Gemini with Google search, and also bundling it with its other apps. So that's one type of tying, where I think that they are clearly distinct products, because Google had its search and there's this chatbot, which are different. We know Google and Bing and others operate these as distinct products, or had done so until chatbots came along. And then there are obviously the chatbot companies as well that operate just the chatbot. So they are clearly two distinct they're two distinct products which are being tied together, rather than just one product of Google search, which has been improved through new product design features. So I think that's one type of tying that is happening, tying or bundling of AI overviews and Gemini with the search results page, and also with Google's other apps. But another type of tying, and I think like this is at least was very clear to me, was just the tying of referral traffic with allowing publisher content to be used for AI training as well. And we talked about Google's monopoly power as a buyer. As a buyer, it is tying access to referral traffic for publishers with using publisher data for AI training purposes. So that's another type of tying. And I think that the evidence of that is very clear.
And from a legal standpoint, you mentioned, and maybe this is kind of good for our international audience as well, you mentioned that the standard for proving tying is a little different in the US versus the EU. Maybe you could, when it comes to requiring proof of coercion, maybe you could walk us through that. That's kind of an interesting distinction in US and EU law, maybe allows the EU to potentially be a little bit ahead of the US potentially on at least on this front.
Yeah, that's very interesting. And I think because this case has some parts of this case, like tying of AI overviews to the search results page, that to your European audience might sound very similar to the Google comparison shopping case, which they had, which was one of the first cases, competition cases, to be brought against Google and Alphabet in the EU, where the complaint was basically that Google had tied its own comparison shopping page to the top of the search results page, and that disadvantaged all other comparison shopping websites. So that, and they've already been thinking about this, and their theories of harm like tying, etc., have space to accommodate this, whereas we don't really have that in the US so far, because there have been very few There have been very few tech monopolization cases in the US. Google obviously is the one big one that we've had in recent years. And Google also wasn't based on tying. It was illegal monopolization section 2. It wasn't based on tying. So we haven't really tested this in court about what tying would look like in a lot of digital markets, and whether the conduct of like having AI overviews at the top of search results page and tying that, whether that would fit tying in the US. I think that's still an open question, and there's not really much that has been decided on it. But I think that EU is a good place to look at because they've already figured out how this can be brought within the framework of tying.
Why is there any reason? I mean, you talk about some of the challenges in the US, but are there any big, high level reasons for why you think the antitrust enforcers have steered clear of making tying allegations when it comes to these tech platforms?
So I think that the Google search case was very limited. I'm not sure why they didn't bring tying allegations, etc. There were a lot of allegations that could have been brought against Google, including for its app stores and for its for how Android was being operated and Google's suite of apps, etc. But they decided just to bring a case based on search and exclusive distribution agreements that Google had entered into with these third parties. I think that could have been just strategy because it's easiest to prove, and I think it's easiest to show that that kind of exclusive distribution agreement is illegal, and it could just have been strategy. But I'm not sure why it is so. But it's definitely, I think it's an open question, and there is much to be answered on what tying would look like in the US in digital markets.
And then I think a lot of people think about Microsoft as the big case when it comes to monopolization. Obviously, there are a lot of ones that are going through the process now, but not a lot of established precedent yet. We're still waiting on opinions and appeals and things like that. Walk us through how you see this being similar or different to the Microsoft case, because that is still how a lot of people think about monopolization cases today.
Yeah, so in the paper, I referred to this as the new Microsoft moment, and I was a bit worried even writing that because I felt like it's such a cliche to invoke Microsoft at the drop of a hat every time we talk about antitrust regulation of platforms. But like you said, it's because that's the biggest antitrust monopolization case that we have. But I do think that this moment is similar to the Microsoft moment in principle, and I think that's because Microsoft, at the core of it, was about a company that had a monopoly in one platform, from preventing that company from becoming monopoly or gatekeeper for the next generation of technology. So Microsoft already had a monopoly in operating system, and operating system was the site or platform where most user activity took place, because mostly people used apps for listening to music or for productivity tasks, etc. But the threat of the internet resulted in Gates writing this famous Gates memo about how the people are going to move from using operating system to the next layer, and most of these tasks would now be done not on domestic apps but on the internet through browsers. And so they were afraid that they would lose this gatekeeper position of platforms where most user activity takes place. And the Gates memo really sort of exemplifies that. And I think that this is a similar moment because Google declaring code red, to me, is analogous to Microsoft's Gates memo. Google declaring code red when ChatGPT came out and became popular is analogous to the Gates memo moment for me, because I think for Google, it already has a similar gatekeeper position in general search. It is the gateway through which you enter the internet, but now it risks losing that gateway status to chatbots and AI answer engines. And so it is now trying to find a way to leapfrog from being just a search monopoly to also monopolizing the next gateway to the internet or to the next generation of technology. So to me, in principle, it looks like a very similar time or a very similar existential threat to what Microsoft was facing back then.
It's really interesting. And then I want to get back to when you were talking about why this is a good case for the DOJ and FTC to put resources into. We've already discussed the timing, right? Like this is great timing for a case because the monopoly hasn't entrenched itself yet. It's at the beginning stages of this new product, which is a more timely way to do antitrust. What are some other reasons why the agencies should look at this and to your mind?
I think that it's because a big innovation incentives are at stake. So the future of the internet is at stake. We do not want to, just like we had monopolies controlling the gateways to the internet in the past, we do not want to repeat those mistakes and not just have old monopolies controlling the new gateways, but also we don't want new monopolies controlling the new gateways to the internet. And so it's important, a case like this would not just prevent Google from monopolizing the new gateways to the internet, but it will also provide a signal to the other like attempting monopolies out there who want to control the new gateways to the internet, that this type of conduct will not be tolerated, and that the DOJ and the FTC now want to act early and are sort of looking at this very closely. So it's both about preventing actual harmful conduct, but also about providing a signal to the others who will copy the playbook of Google, both in Web 2.0 and also what Google is doing now to do similar things, and tell them that this is not something that federal regulators or state regulators will tolerate. So I think that it'll have so many effects. It'll affect innovation, and I already touched upon how it'll have spillover effects in a lot of different markets. So it's not just about search engines, it's also about AI chatbots, it's about publishers and the future of publishers and ad revenue for them.
And you mentioned you wanted to touch on the likely success of this type of case. Like, what do you think really makes it compelling? Obviously, you wrote a paper all about how the litigation would work, but just in terms of the evidence and the moment, where the courts are, why do you see this as particularly likely to be successful? And then we've got four questions here from our listeners to get to after that.
So about the moment that we are in, I think that so in some ways, this is a very good moment to bring this case, because I know that there's an overall sense of disillusionment with the remedies that antitrust is capable of imposing, or even just general regulatory and judicial appetite for imposing good, strong remedies in antitrust cases. But I think that this is a good moment to bring this type of case, because even a very simple remedy here could go a long way. So by simple remedy, I mean even like a simple injunction, which tells Google not to use publisher data in all these additional ways, and to give publishers the option to opt out of their publisher data being used in all these additional ways, while retaining their right to be, allowing their data to be used for the creation of search index. I think that's just a simple injunction. Even a simple remedy could go a long way. So I think another reason why regulators should be interested in taking up this case is because the remedy here is clear, and it's clear just because we're acting early. Once the market does get monopolized, remedies to restore competition in digital markets are much more difficult to design, or convincing a court to implement it is much more difficult, especially as courts have proven themselves to be so cautious and conservative. So it's a good reason for regulators to bring this case, because I think the theory of harm is clear, the remedy that you are going to ask for is clear, and it's all because the remedy is so simple, it's more likely that a court is going to grant it. So I think for all those reasons, I think it's a good moment to bring this case. But like at the same time, I'm not very optimistic that a case is going to be brought by federal regulators right now, because of all the national security rhetoric that AI tends to get couched into. There is this phantom of the US-China AI arms race always looming in the background. So I'm not very optimistic if a case is going to be brought, but for that sort of argument, I would say that one should closely examine the assertion that less competition or protectionism is good for creating strong American tech companies. I think more competition is better for creating strong American tech companies. And therefore, even from a national security perspective, I think subjecting your big tech companies to competitive discipline would help you win the US-China AI arms race, assuming that's a normative goal you want to pursue.
We have two other, well, we have, what do you think about the states and the EU? Obviously, the EU is considering their own tech stack interests now. They and the states, obviously, to some extent, have been showing signs of ramping up their interest in bringing antitrust cases, showed a lot of leadership on Google Ad Tech, for example. What do you think about just the opportunity for the states or the EU to step in here? It seems like they have different and opposing incentives from what you're saying from a national security, I would call that, the red herring argument or whatever you want to call it. Seems pretty patently disingenuous on many levels, but what do you think about when it comes to states and in Europe?
So in many ways, this paper was written for state AGs. I mean, that was the audience I wanted to get to, because I wasn't optimistic that federal regulators would act on it because, as you rightly described, the red herring national security argument. So I think state AGs have the same powers, and you had excellent interviews in the past on Capitol Forum talking about the role of states in antitrust enforcement. So there is some discussion now about states taking on a more proactive role in antitrust enforcement, and I think states have a lot of power under state regulation and otherwise, and so they can bring all of these same theories of harm, and they have their own state antitrust statute. And I think that, as some instances in California have shown us, that state regulations have spillover effects, and sometimes when tech companies comply with state level legislation or state level enforcement action and remedies, they would end up implementing that not just in a specific state, but would do it for the entire country. So I think it would have the same effect, and I'm hopeful that state AGs would act on it. EU, of course, has been very proactive, and it has its own set of geopolitical tensions right now that it has to cater to. That being said, complaints have been brought by independent publishers before the European Commission on very similar theories of harm, so they will be called upon to decide it as well. And apart from antitrust, because EU has been so active on the ex-ante front as well, I think EU could also explore more regulatory options. So, for example, Australia has the News Media Bargaining Code, which targets some very similar things, ensuring that publishers can negotiate fair compensation with distributors and platforms like Google and Facebook, etc. I think Europe could also explore similar options. I'm not very sure if they are already doing that, but I think that a few countries like Australia have done it, and it would be given EU's regulatory appetite for doing ex-ante regulation, I think it would be an interesting sort of template to look at.
And we've got listener questions here. Here's one. We know that Gemini and search existed separately for a time. How do you think consumers think of them now? This seems particularly important for the claim they are two distinct products. We talked about this a little bit, but this specifically asking about the consumer perspective when it comes to Google, Gemini, and search. What are your thoughts on that?
Yeah, that's super interesting. I think that point, that's very interesting, because usually distinctiveness of products and that assessment does not really depend so much on consumer perception, but I'm sure it plays into the mix. And it also means that right now we still have most consumers who use the Google search now have seen Google search without AI overviews. But your listener is right that as time passes, it will be more and more difficult. And as these products get more and more integrated, it will be difficult to see them as being distinct, especially as a very large part of Google search results page ends up being the AI overview. So that argument, you're right, that argument might be more difficult to make as time passes on and people start perceiving Google search as not just search, but search plus AI overview, because that's the feature now.
I think it depends on what this user means by consumer. Obviously, the publishers are buying or otherwise selling. I guess they're interacting with these products, so they're users in some respect, but he's ostensibly thinking about an end user, I would imagine.
Yeah. And just
Yeah.
on like success also, I think that the whole monopoly story of Google being the monopoly buyer of publisher data and holding power there, I think that's the stronger argument that one should run with, especially as we don't know what tying is like, what the tying doctrine is going to look like in digital markets.
We've got another question here. How did this topic make its way, or could it have made its way into the Google search case remedies? Not exactly. Yeah, go ahead.
So I don't have too many thoughts on it, apart from one solution to this, one potential solution to this, which some people might find maybe a little bit more extreme, but one potential solution to this is having line of business separation or structural separation, that Google already has a monopoly in search engine, and so it should not be allowed to enter this like separate market of AI-powered answer engines or AI chatbots, which is structural separation argument or structural separation remedy or line of business separation remedy. That type of remedy could be demanded in a case like this. I think like the only Google remedy, the Google remedies decision and the Google search case connection that I can make here is that DOJ asked for a very similar looking remedy in the Google remedies trial phase, asking that Google not be allowed to invest in AI, and that was rejected. So maybe that makes such a remedy in this case also less likely to be accepted. But apart from that, like, yes, one way in which the whole Google case is relevant is that we already know that Google is a monopoly. So Google's monopoly has been established. We've gone through the process of defining the relevant market and showing Google's monopoly power, and we don't have to do that all over again in a case like this.
I have a question here that I'll admit I do not understand. It just says illegal reciprocal tying. Is that just what we were talking about tying, or is there something, is this reciprocal tying a term of art I'm not familiar with?
I think there's reciprocal dealing, but there's also tying, and I think this is tying, so not sure.
All right, well, you know, let's end. Oh, here we go. Here's another question. We're out of questions, but maybe the last question I have again is just to take a step back and think about this moment again. You know, I think there are broader themes here with a lot of people questioning, you know, rule of law, questioning fairness in the courts, questioning power that these companies have over our lives. What are some of, you know, we talked about this, the threat to democracy. You briefly touched on this, but what are some of the bigger picture reasons to bring a case like this now? I mean, you mentioned in the Microsoft example, you know, this really that case really did deter Microsoft from extending its monopoly. Obviously, it's still somehow endured as a monopoly to this day, but at least temporarily opened the door for more competition. That case, mergers were scuttled that Microsoft otherwise would have pursued. It was a big check on corporate power. What do you think about this moment, these broader themes, and the opportunity that this type of case would bring to at least address some of those concerns and fears about, you know, threats to democracy and rule of law?
Yeah, so so much to unpack here. But there's, I think, like, very quickly, two things: future of the internet and also democracy and rule of law. So on future of the internet, I think that it's always sort of difficult to imagine what the counterfactual world would look like had there not been a Microsoft antitrust case. But a lot of people have very persuasively argued, like you said, that had it not been for the Microsoft antitrust case, all these amazing tech companies would not have emerged, which also ended up becoming monopolies in their respective markets, but you would have no Google and Facebook and so on and so forth. But back in that moment, it was very difficult to predict what that company could have been had at least when the Microsoft trials were going on. Similarly, it's very difficult to say now what the technology would emerge if we allow Google to not monopolize these markets. But there are, I think the fact that there are so many AI startups that are putting in so much resources and money into finding alternative ways to access the internet means that there are some good ideas out there, and we should give them an opportunity to win. And if we allow Google to leverage its monopoly position in search to also monopolize these future markets, we would not be giving them any opportunity to succeed or a fighting chance. So I think that it's difficult to say what the future of internet would look like, but the past has told us that more competition is better, and so we should pin our hopes on that. On future of democracy and on democracy and rule of that, I think that this is so important because a lot of what is at stake is not just digital markets, but publishers and journalism. And we already see that having fewer players in media also means that the government it's easier for an autocratic government to control those media companies. And therefore, I think it's very important that we ensure that there are more and more publishers. There's more plurality of publishers in the marketplace who cater to different consumer bases. And that's very important to ensure that, like, the fourth pillar of democracy, which is the press and media, actually has a chance to survive. But yeah, these are such big issues.
That was a great answer to an impossible question. So I thank you for that. We've got one last question from the audience. Do you see there being a middle ground between publishers' content either being used for AI overviews or not being used? And specifically, are there any workable monetization models that would allow for the continued use of AI overview while also protecting publisher revenues? The idea that we just stop Google from using AI overviews seems like trying to stop an emergent technology. A bit of a leading question. Curious if this person works for Google, but go ahead, Madhavi.
Yeah, I'll take my best. So even if AI overviews are good and they are consumer welfare enhancing, that's what consumers want, and hence that's what we want Google and consumers and publishers to have. What publishers still deserve and they are entitled to is fair compensation. So the monopoly profits that come from AI overview, we still need to find a way to compensate publishers for their data that has been used in training those models and in creating the summaries of content in AI overviews. So maybe like what you do when you prohibit Google, when you impose an injunction in a case like this and prohibit Google from using publisher data in all of these ways, is that you force Google to enter into licensing agreements with publishers, or you force them to figure out some other model of payment, for example, pay per crawl, etc., so they don't end up cornering all of those profits for themselves, but like some of it goes back to publishers who provide this content.
Yeah, as a publisher, the point I would make, you know, and I think you were right to suggest that there are companies that are going to be afraid of making a monopoly argument, even if it's in their best interest to have competition here, so they could potentially win that competition on the merits, as opposed to just defer it to Google. But publishers, it is short-sighted, in my opinion, for these companies to decimate the publishing industry because they need publishers to train the data. It's going to be a crummy product. Like Google got crummier, got worse and worse and worse because they just put ads on it. I literally can't even use it because I can't tell what is an ad and what is a link anymore. I mean, maybe if they hadn't done that, you wouldn't be so easily replaced by a chatbot that is serially stealing copyright, you know, stealing people's content. And obviously, in this respect, I am a publisher who vigorously defends our copyright. But I do think at some level it's short-sighted that, like, look, if this product is going to be good and accurate and useful to the citizenry, it's going to absolutely depend on a robust publisher industry. And in fact, you're seeing the licensing happen already because they're losing in court on the copyright claims. And to me, that's really where the rubber meets the road. It's this, you can no longer have a license to steal content, you have to license it. And to me, you know, this is another avenue of ensuring that that payment occurs in a way that makes market sense. And to me, there's no such thing as a chatbot model with no publishing industry, because they're just so heavily reliant on those inputs being of a high quality nature. You're just going to have garbage, you know, amateur and erroneous content that filling the bot, and then that's going to be useless. So, and then, you know what, that might open the door to a good search engine potentially. No, but Madhavi, this is an amazing conversation. So much to go through, so many tough questions, so many interesting things. I'm super excited to see how our audience of state AGs and policymakers at DOJ and FTC respond to this paper, and how the courts look at it in the future. Hugely influential work, and thank you so much for joining us today.
Thank you so much for having me and for your excellent questions. Thank you.
We're concluding the call. Thanks for joining us today. If you found the conversation helpful or thought-provoking, please be sure to follow the Capital Forum on LinkedIn, X, and Blue Sky for breaking news, policy updates, and information on upcoming events. We'd love to hear from you. Drop us a line at events@tcfpress.com if you have ideas for future topics, speakers, or just want to connect with us. Have a great day, everyone. Thanks again for doing this. Thanks so much, Madhavi.
Bye. Thank you.
Bye.